My name is Michael Young, and I'm a lawyer who handles contested estates in Texas. What is a putative spouse? Well, a putative spouse is a spouse who believes that they're married in good faith, but legally they're not. Well, how does that happen? Well, it happens a man or a woman meets somebody else, they date, and they decide to get married, and one part of that marriage one party believes that they are married. And then one day, lo and behold, sometimes when their spouse dies, they find out that they weren't. And the reason that they weren't legally married is because their spouse had previously been married and that marriage had not ended either in death or divorce. You can't be married twice in Texas, and there is no such thing as a common law divorce or an informal divorce or a quote-unquote legal separation. You're either married or you're divorced, or your spouse dies and the marriage ends that way. So what happens to the spouse who was not legally married? Well, that's where the putative spouse doctrine comes in Texas. And what that doctrine says is that the putative spouse can still receive a certain amount of assets from the deceased husband or wife that they would have received otherwise, generally, half of the assets acquired during marriage, if they had no reason to believe that their husband and wife had previously been married. In other words, if they were deceived, then they can inherit from the deceased person who they believed was their spouse. Now, is this a situation that comes up a lot? Not really, but I have had a case in the past where it has become an issue, and that had to be pled and proven in order for my client to receive a significant portion of the assets. If you're dealing with a situation of a putative spouse or a situation involving a dispute over the existence of a marriage, typically a common law marriage, give me a call.